a collaborative presentation of the Federation for Children with Special Needs and the Recruitment, Training, and Support Center. My name is Janie Greco, and I'm the Training and Support Specialist at the RTSC. Today's webinar is SpedEx, a Massachusetts alternative dispute resolution option, presented by David Scanlon from Boston College, who is the SpedEx program administrator. David, you'll tell us a little bit more about yourself when it's your turn, right?
Sure, absolutely.
During the webinar, please type your questions in the toolbox and we will try and answer them during the presentation. Past webinars are archived on the RTSC website, along with many resources on trauma and learning and educational issues that impact students in child welfare. Please note that SpedEx is not affiliated with the Federation for Children with Special Needs. It is fully funded through the Department of Early and Secondary Education in Massachusetts. Welcome, David. We're so glad you're here.
Thank you, Janie. I'm very glad to be here. And I want to thank the Federation for hosting us today. And thank you for reminding everyone that SpedEx is sponsored through the Department of Elementary and Secondary Education, specifically the Special Education Planning and Policy Development Unit. Thank you very much. So I'm delighted to have this opportunity to talk to everyone and tell you a little bit more about SpedEx and how we work. Our agenda for the day is that I'll introduce SpedEx in terms of our mission and our focus, talk a little bit about why you might want to use SpedEx when we are appropriate, and then briefly go through the stages of the process and wrap up the day by talking about our record of success. And I'm pleased to report it is, by and large, a record of success. We're not perfect, but I think we're pretty good. And tell you a little bit more about how to find more information about our consultants and about using SpedEx if you think it might be appropriate for you. So, to begin, I'd like to just explain briefly about the SpedEx mission. And first and foremost, I'd like you to know that because we are sponsored through the Department of Elementary and Secondary Education, that SpedEx is free to both schools and parents. And first and foremost, we are a child-centered option for assisting those parties, schools and parents, when you have an IEP dispute. And specifically, we assist parties in IEP disputes that address FAPE, or free and appropriate public education, and or the least restrictive environment, the LRE. As we talk today, we'll talk a little bit more about what happens when there are other areas under dispute and what cases are eligible, but first and foremost, please be aware that we are specific and exclusive to disputes concerning FAPE and LRE. And the other thing I'd like to tell you about our mission is that what we do is we provide the parties with a, quote, neutral recommendation on whether or not the rejected IEP would in fact satisfy FAPE and LRE. And if not, we make recommendations as to what would be necessary in order to achieve FAPE and LRE. And I'd like to stress the words neutral and recommendation. One of the virtues of SpedEx is that when the parties, the school and the parent, are in dispute and they just can't come to agreement, we provide an outside perspective on what would be appropriate in the child's best interest. And our recommendations are that, just recommendations. It's our hope and part of our mission that we are going to be able to help the parties to resolve your own dispute. So we provide you with a neutral perspective, a fresh perspective if you prefer that phrasing, and then it's up to you to see if you can resolve your own dispute. Right. So as a reminder, SpedEx is funded specifically by the Special Education Planning and Policy Development Office within DESE. And here's a little background on why you might want to use SpedEx. Take the year 2015. There were approximately 980,000 students in Massachusetts, and that included 165,060 IEPs. And of those IEPs, just over 10,000 were rejected in 2015. Some of the other options available when there is a dispute for schools and parents is mediation, and you can see the statistics that I have at the bottom of the screen here. One of those options, again, is mediation. There were 790 decisions in 2015 through mediation. Another option is a hearing. There were 18 decisions for hearings, and additionally there were 48 substantive rulings, which means that there wasn't a hearing decision so much as a ruling or a recommendation was put in to effect that the parties agreed to. And also Massachusetts offers facilitated IEPs, and there were 127 facilitated IEP meetings during 2015. So as you can see from these statistics, just a fraction of the rejected IEPs go to the currently available dispute resolution options that exist in Massachusetts, in addition to SpedEx, which is our experimental alternative dispute resolution option. I certainly want to emphasize that all of these options serve purposes and certainly might be more appropriate for a given dispute than with SpedEx, and that'll be one of the things we want to talk about today. I think that Massachusetts and Massachusetts schools and families benefit by the fact that we have so many different dispute resolutions available to us. So let's talk a bit more about why SpedEx in particular. One of the things that happens through the SpedEx process is that we promote trust between the parties, between schools and families, because unlike, for example, a mediator who comes in or a facilitated IEP where the facilitator comes in and guides you through your discussion of the IEP deliberations, or unlike a hearing where ultimately a ruling is made that's binding, at least to the schools, and is really the final stop before going to court, which is almost always a very unfortunate choice. In the SpedEx process, what we do instead is we provide information to the parties before you go to such a formalized level of dispute, and we hope that that's going to help to engage the parties in working together and restore or build trust between the parties. And we consider SpedEx to be very efficient. For most disputes that we deal with, the parties do find that they're able to work together, and that consequentially means that that's the most efficient process that they can follow through to get to a signed IEP and to maintain that positive working relationship that's part of our mission to help build. So let's talk a little bit now about what disputes are eligible for SpedEx. There are a few possibilities. First, there must be a currently rejected IEP. I'm sometimes contacted by schools or parents or advocates who are anticipating a rejected IEP, and we certainly will talk about what's going on there and whether or not SpedEx might be appropriate if a rejection in fact happens. But I always encourage the parties to continue in the process and see if it isn't possible to resolve your dispute and not prematurely jump to the option of going to SpedEx. So there must be a rejected IEP, and alternatively, if the parties have not formally rejected the IEP, but they've found a way to begin the process of scheduling either mediation or a hearing, then they are also eligible to go the route of SpedEx. So I'd like to point out that it is possible to schedule mediation or a hearing and simultaneously schedule SpedEx. I always ask that you let us know that this has happened, and it's also important that you let the mediator or the hearing officer know that you've selected this option. Indeed, we are in very good terms with our friends at the BSEA, the Massachusetts Bureau of Special Education Appeals, and very often mediators and hearing officers will recommend to parties that they consider looking into SpedEx. The advantages of participating in SpedEx when you think you might want to pursue mediation or hearing include that we might be more expedient than either of those processes, and then you could drop out of those processes if you reach satisfaction through SpedEx. And if not, then it's possible that you'll receive a SpedEx report, and that will be valuable information, a useful resource that you all, including the mediator or hearing officer, can use in that next process. I want to remind you that the disputes for SpedEx must concern FAPE, appropriate education that is, or the least restrictive environment. There are very often additional areas of concern. It might be reimbursement for unilateral placement. It might have to do with transportation or outside service providers. SpedEx will not comment on those aspects of a dispute. So if parties consider those aspects of a dispute important to be addressed, you've got to determine whether or not you can handle those yourself outside of SpedEx, or look into what other options you might want to deal with those. Certainly, we will take a SpedEx case where there are those other aspects of a dispute going on. However, as I just said, we will not address them specifically. And finally, I'd like to point out that both parties must voluntarily agree to participate. It may involve advocates and or attorneys. And as it says on the screen, those individuals are not needed in order to engage in SpedEx. And I'll remind you that's because our mission is to help the parties, the school and the parents, the families, to build and or maintain positive working relationships with each other. We absolutely have had many cases that have included an advocate and or an attorney, and attorneys could be from either the parent or the school parties, and those disputes have always proceeded just fine through the SpedEx process.
David, can I interrupt with a question?
Oh, please do, Jane. Thank you.
So the dispute concerns have to be FAPE or LRE. Is that because they're federal issues and not state issues?
Not really. Actually, the idea for SpedEx is centered on the idea that we may be able to help parties resolve their own dispute before the dispute escalates. And we recognize that the primary area for IEP disputes is around FAPE and LRE, and so we thought that would be the most targeted.
Okay.
Yeah.
The reason I'm asking is that the new Every Student Succeeds Act,
Yes.
Which is going into effect within a couple of days,
Yes.
has a lot to do with transportation for kids in public and child welfare.
Right.
And in that case, you would not be addressing that specifically.
That is correct.
Okay.
That is correct.
All right.
Right.
I just wanted all the SESPs out there to realize that we're anticipating a lot of issues around that.
Yes, I'll bet there will be.
Yes.
Yeah.
All right. Thank you.
All right. Quite welcome. Quite welcome. So we might say a little bit more, in fact, than about the concepts of FAPE and LRE. Going all the way back to the first United States Supreme Court case on what was then the newish special education law at the federal level, the Reilly versus the Hendrick Hudson School District of Rochester, New York area. One of the lower court case decisions included the phrase about special education and FAPE specifically being about a serviceable Chevy, not a Cadillac. And that reminded everybody that the idea of appropriate education is that it's about providing students with benefit, which we now understand to be meaningful benefit, but not maximum feasible benefit, which is a concept that we once applied as our standard here in Massachusetts, as did several other states, but no longer is that the case. And the idea is that it's supposed to open the door of public education to, quote, handicapped children, to use the phrasing that was used in that court ruling. So according to the IDEA, which is our federal special education law, and so of course it's also consistent with Chapter 766 here in Massachusetts, special education, FAPE, therefore, must be provided at public school expense. It must be consistent with and meet the standards of the State Education Authority, RTSC, and it applies to preschool, elementary, and or secondary school education. And of course, it must be conforming with or consistent with what is agreed to and signed and adopted IEP, which that's almost a circular statement because, of course, an IEP has to contain things that are only comport with the law. FAPE requires that special ed and related services permit a student to make meaningful educational progress. And that, of course, is a very important standard that we consider when we are making recommendations to the parties in our SpedEx report. And FAPE must be provided in the LRE, which again is the least restrictive environment. And let's just say a little bit more about that, quoting straight from federal law. Then we are required in special education to the maximum extent appropriate, which is something determined by the IEP team, to the maximum extent appropriate, children with disabilities should be educated with children who are not disabled. And as the law goes on to state, special classes, separate schooling, other ways of removing children with disabilities from the regular education environment should occur only when the nature or severity of the disability is such that education in regular classes with the use of supplementary aids and services cannot be achieved satisfactorily. And I always like to point out that that final clause is actually quoted in the recommended IEP form that's available through the DESE to local school districts. It's such an important thing for us to remember when we're determining appropriate placement. So with those ideas in mind in terms of what SpedEx addresses, the next slide is going to be slightly overwhelming to folks. It lays out the steps of the SpedEx process. And I'm going to recommend to you that when we get to the final slides today, it's going to include the website for the SpedEx program where you can go and find these steps listed out in greater detail, and you can download a brochure that lists and explains these steps as well. I won't go over each step in tremendous detail as they are listed here, but I'm going to just kind of walk through these 10 steps of the overall process to guide everybody in terms of understanding exactly how SpedEx works. So it begins with either the school or the family parties making a contact with me as the SpedEx director to determine whether or not we might be appropriate to use in your dispute. Excuse me. After you provide brief explanatory information about the nature of your dispute, I can help you understand whether or not it might be consistent with what SpedEx Mission does address and the things that we do not address in SpedEx cases. And also we can have a frank conversation about whether this alternative or perhaps mediation or a hearing might be the approach that you might like to consider. Because part of the SpedEx mission is to help the parties maintain or build positive working relationships, when one of the parties contacts me, I always ask them to invite the other party to see if they will agree to join in SpedEx. Remember, we are a voluntary process. I'm always available to speak with the other parties, and we can give them our website address, send them a brochure if they'd like more information about SpedEx and how we work. We're a relatively new program. We're still experimental, so don't be surprised if school districts or advocates, and of course parents themselves, have yet to hear about us or certainly don't fully understand us or don't really know much yet about our record of success. So I'm always glad to provide more information if a party's just uncertain about SpedEx and how we work and what we have to offer. Once the parties agree to use SpedEx, the next step of the process is to visit our website, where they can view the biographies of each of our 16 SpedEx consultants. And I ask that the parties, in that spirit of working together, jointly review the list of consultants and identify from 1 to 3 consultants that they would accept to take on their SpedEx case. In the name of efficiency, I ask you to give us multiple names, because once you select those names and give them to me in priority or preference order, then I'll start contacting the consultants immediately and ask them if they will be available to take the case. For various reasons, of course, a consultant may consider there to be a conflict of interest. They may not believe that they have the appropriate expertise to take a particular case. Then I'll quickly go to the next name on the list, and that way we can notify the parties as soon as possible which consultant they've agreed to will accept the case, and the process can begin virtually immediately. We like to communicate through email as much as possible, so it's kind of a record that's available to all members of the party, and it turns out to be a very efficient way to have three-way conversations among the school and the parent and the consultant. Our experience in this process is that once a consultant confirms that she or he will accept the case, that we put everybody in touch immediately through email, and the case can begin within 1 to 2 days on average. So that's a very fast startup process, I'm delighted to report. The first order of business then is for the consultant and the parties to agree if they will start the case immediately. On occasion, we have a need for a delay because of school vacation schedules. Sometimes if the case begins very late in the school year, we have to make a determination about whether it makes sense to begin the case or schedule it to begin first thing in the new school year. And that might concern whether or not the student's receiving extended year services, for example. There may be religious observations or a health need for any one of the parties, and that could potentially delay the case beginning. But typically they begin right on schedule, and we ask the consultant to take 30 school days to do her or his fact-finding and then to issue that recommendations report. The recommendations report is based on a variety of data gathering. I'm going to catch up my slides to what I'm talking to you about now. So we've just talked about how to initiate the process. I'm going to move forward to the next slide, and here we are. So what happens for the data collection phase of the process is the consultant interviews the parties separately, And I should note that this is different than how parties are interviewed in both the hearing and in the mediation process. This provides an opportunity for the parties to speak without the other party present and to have an ongoing one-on-one conversation with the consultant. Also, the consultant must review the rejected IEP and whatever other documentation the consultant deems appropriate. And of course, that determination is made in part by the consultant talking to the parties and understanding what documentation they think the consultant should be looking at. The consultant also observes the child. We observe the child in their current placement. The consultant will not, I'm going to advance to the next slide for just a moment. The consultant will not visit alternative possible placements for the child. We only observe the child where he or she is. And we typically do not make home visits in addition to observing the child in a school placement. In those instances, because of the nature of a child's disability and the services that he or she is currently receiving, if there are home services that are part of FAPE, then it could be appropriate for there to be a home visit. And at the discretion of the consultant and the parents, it's possible that the interview that the consultant does will be done face-to-face in the home environment, but we do not formally make home observations either. Also, while we're looking at this slide of the things the consultant does not do, we'd like to be clear that this is not an evaluation of the child. Instead, this is an observation of the child and how the child interacts and functions and is participating in her or his current placement. Okay. Backing up to my previous slide for just a moment, after the consultant gathers all of that information, interviews whomever the appropriate parties are for the school and for the parents, which may include advocates and or attorneys if they are involved, then the consultant reviews all of that information and issues her or his recommendations report. I, as a SpedEx administrator, always preview that report, and I never want to second guess, and I don't second guess the consultant's recommendations. However, I do review the report just as a friendly editor to be sure that it's going to be a report that will make sense and can be comprehended by all of the parties, and to be sure that the consultants are consistent with the scope and mission of SpedEx before that report gets issued. I'd like to remind everybody that once a consultant issues a SpedEx recommendations report, that it must become part of the student's permanent school file. That is not something that can be renegotiated. That was agreed to when everybody began the process, and we will honor that. When the parties receive the report, which I send to them, we ask them to review the report and let us know within 10 days, and sometimes it takes longer than that, but within 10 days if they would like to have a meeting with the consultant to explain her or his report. If so, and both parties wish that meeting, it must be a joint meeting. However, if only one of the two parties wishes to have that meeting, then of course the consultant could meet with that party alone. All right? And I'll remind you that the purpose of that meeting is strictly for the consultant to explain how he or she arrived at the recommendations concerning FAPE and LRE and a potentially signable IEP. I always remind the consultants before they go out to those meetings, and so I'll remind you here that because we are providing you with a neutral recommendation so that you may resolve your own dispute, that if in that meeting you begin to deliberate a new IEP, the consultant must step out of the conversation. They cannot and will not participate in deliberating the new IEP. They're only there to answer your questions about their recommendations.
David.
Yes.
A quick question. Is this an appropriate service for kids that have been denied to be eligible for an IEP?
Unfortunately, it's not.
Okay.
If there is no existing IEP, then SpedEx cannot be used because by default there is no rejected IEP.
Right.
Now, if the question is about continuing eligibility, then yes, we could be involved.
But the initial decision is not a SpedEx concern.
That's correct,
okay.
Unfortunately.
Thank you.
I'm glad that was an important question. I'm glad to have these questions. I get to know what people are
the audience usually is pretty good at
always
this.
one step ahead. That's wonderful.
Yeah.
Great. All right. Once an IEP once the SpedEx recommendations report has been received and reviewed, we are very hopeful that the parties can resolve their dispute and come to a signed IEP. I'll give you a sneak to what we're going to talk about in a few minutes and tell you that we have an approximately 90% success rate in terms of accomplishing signed IEPs. In the event there is a signed IEP as a consequence of the SpedEx consultation process, then the parties have the option, if both parties agree to it, to invite the consultant to come back to do a follow-up observation and report once the child is in his new placement. And ideally that should be done within approximately 30 school days of the child arriving in that new placement. And to be very clear, the purpose of this follow-up observation and report is strictly to comment on whether or not the FAPE and LRE, the appropriate education and least restrictive environment that have been agreed to in the new IEP are being provided. And very often, in fact almost always, the reports include very minor recommendations on how there might be slight adjustments to the services and placements provided in order to best achieve the agreed to FAPE and LRE. This is in no way a performance review. This is in no way an evaluation of the child, and it's certainly not intended to reopen debate about the IEP, but rather just to help the parties fine-tune, if I could use that expression. This is an optional process both parties must agree to if it's to occur, and if one of the parties would prefer not to, then it cannot happen. And interestingly enough, Janie, this process is only chosen by the parties in about 80% of our cases that result in signed IEPs. So sometimes they don't feel a need or a desire to go forward with it. And certainly that's fine. At this point, the SpedEx process is fully concluded. That case is considered complete, and we have completely stepped out of the process. So if I may now, I'd like to talk a little bit about our record of success. As I mentioned earlier, SpedEx is a relatively new program, and one of the things I never realized I'd have to do when I took on the role of SpedEx administrator, which I inherited from my colleague, Dr. Alec Peck, was that I'd have to help to advertise SpedEx. We've been working heavily to get the word out that our program exists, and we're very grateful again to the Federation for facilitating today's webinar. It's just one of the many ways we try to get the word out. We're getting there. We have so far had contacts, which doesn't mean the same thing as having a case, but we've had contacts come from approximately 93 of the Commonwealth's 393 school districts. So right about 24% of the districts. A contact means that there's some kind of inquiry for information. It might be specific to whether or not SpedEx might be appropriate for a dispute or a looming dispute, but sometimes it's just to gather more information. Inquiries come from parents. I use the term administrators. There are many different people in the school side of the process who might be involved, typically at some level of special ed or school administrator. We also get contacts from advocates, and on occasion we get a contact from an attorney as well. I'm delighted to report that several school districts that have used SpedEx for an IEP dispute have requested or agreed to participate in using SpedEx multiple times. Parents are approximately twice as likely as schools to be the ones who are contacting SpedEx and inquiring about potential cases. We have had SpedEx cases at all schooling levels, from pre-K, pre-kindergarten level, up through secondary age level appropriate cases. And we've had approximately equal amounts of interest at both the elementary and secondary school levels, which school or age group levels, I should say, which is where the majority of our cases have come from. Mirroring state and national trends in terms of who's most likely to be involved in an IEP dispute based on category of disability, the majority of our disputes have involved the autism spectrum and the mild and moderate disabilities, as we often refer to them in Massachusetts, but which are increasingly being known as the high incidence disabilities, such as learning disability and ADHD, and intellectual and developmental disabilities. Those are the categories where we most often get requests and actual cases for SpedEx. This graph shows you the trends In terms of who contacts SpedEx, if you have good color resolution, you can see the topmost line is the darker purple line, and that's the total. That's the aggregate of contacts from parents and guardians and advocates and school parties, which I've labeled again as administrators. So you can see overall, since we began in the 2008-9 school year up through last school year, 2015-16, that we've had a relatively steady increase in terms of number of overall contacts. Continuing to look at this graph, if you can see the next line down, that pale blue line, that's specifically parents and guardians who have consistently been most likely to contact us at about double the rate of school administrators. The school administrator and the advocate and attorney, which of course is a parent party, you can see how those lines kind of crisscross one another, indicating that relatively equal level interest, or contacts, I should say, by those parties. Looking at our next graph, looking at our next slide, which is not a graph, this is just a delineation of the number of cases that we've had to date. We are currently funded for 8 cases annually. Going back to 2008 and 9, our first year, we had a single case, and that was our pilot year. After that first case, we in fact temporarily stopped taking cases so that we could retune the process based on things we learned from that first case. The trend, if you follow through the years, shows that we've had 5 and 6 cases up to the year 13-14, where we had a total of 9 SpedEx cases. And if you fast forward to the current school year, 2016-2017, here we are in mid-December, and we've already had 5 cases launched. So that indicates that we are on record to break the number of case records that we've had so far. The majority of cases historically have been initiated in spring, which I euphemistically refer to as IEP season in many school districts. The second most likely time period is the beginning of the school year. So since obviously these cases came from the beginning of the school year, we predict that we're very much going to have a banner year in terms of SpedEx. We're really catching on is what that means. If you look at the statistics down below, we've had 41 cases begin. That includes the 5 that are currently underway. 32 of those cases have led to an IEP decision. 29 of those have been to sign and accept the IEP. That includes 3 cases where, in fact, the parties did not come to agreement, and in those instances, it was in each case the choice of the parent not to sign the IEP and to move forward onto some other dispute resolution option. We did have 3 cases that dropped out before completing the process, however. And if you're doing your math, those numbers don't quite add up to 41, and that is because all of the current cases, plus a case that was completed just at the very end of the prior school year, we have yet to reach the point where parties have made a decision about signing an IEP, but that certainly does not indicate that any of those cases are necessarily in peril for not reaching agreement. If we look at the next slide, this just shows you graphically the number of cases we've had based on schooling levels, and as I explained earlier, the majority of our disputes have been at the kindergarten through 6th grade, the elementary school level, followed by the secondary school level. We have it divided out here by grade 7 and 8, middle school, junior high school years, and the high school years, which is 9th through exiting special education, which of course may take an individual, an adolescent, young adult up through age 22. The next slide shows us another bar graph, and this just reiterates the points I was just making in terms of which disabilities tend to be most commonly used for IEP disputes. Autism spectrum disorders and intellectual and developmental disabilities, followed by other health impairment, which is not exclusively ADHD, but a large percentage of those cases were ADHD, and then specific learning disability. Some people might be surprised to see that there's undetermined, and that we've had a few cases in which the disability is not been officially determined. These are, I'd like to reiterate that we only are available when there's a rejected IEP. By default, of course, that means the child is in fact already been enrolled in special education, and so what's going on is the child's disability is evolving, and the parties agree that it is unclear exactly what the most appropriate disability is for the child at this time. But of course, special education can't always wait for a diagnosis. This pie graph is not quite up to date, I confess, but it's only going to look fractionally different from this. This shows our 90% success rate. The large blue field indicates what percent of cases that have come to completion have led to a signed IEP. Those 3 cases that led to some other option are represented by that, shall we call that a brown section, Janie?
Brown or red.
Brown or red.
Yeah.
All right, thank you, that helps. And green represents the fraction of cases that are ongoing at this time. So a little bit more about the SpedEx record, and then I'll stop dominating the conversation and we'll have even more questions, I hope. Overall, participants report that they have been satisfied with SpedEx, and among the things that they cite in particular are the efficiency of the overall process and that they've been able to receive a neutral perspective from an informed SpedEx consultant who can help them to think through from a fresh perspective. So who are those consultants? The consultants currently include 16 experienced special education professionals. They include higher education faculty like myself. They include practicing school teachers and service providers. They include former special education administrators, a range of individuals who have expertise in special education and related service areas. We are diverse in terms of our background, our specific areas of expertise, the years and breadth of professional experience, and the geography throughout the state. The website address for SpedEx is spedexresolution.com. It's provided at the bottom of the screen, and it will also be provided to you again on one of the very final slides of the webinar. And if you go there, you can link to a page where biographies of each of our 16 consultants are available, and those are what are primarily used by the parties when you're determining who you would consider to accept your case.
David,
Yes.
is that who makes the decision about who will be the consultant? Do you make that decision?
Yes.
Okay.
All of the consultants must have an advanced degree, which would mean at least a master's degree in special education or a related field. They must have a minimum of 5 years professional experience in special education or a related field. And they also must provide 2 letters of recommendation from professionals knowledgeable in the field of special education who speak specifically to their appropriateness to work as a SpedEx consultant. And then they have to participate in a SpedEx training process with me, and only once they pass that process are they then eligible to participate as a SpedEx consultant.
So the people that are asking for the SpedEx service cannot decide which person they're going to want as a consultant?
Oh, in fact, they can.
Oh, they can.
Yes.
Okay.
They must select them from the approved pool of the 16 consultants available on the website.
Okay.
But absolutely, in fact, in the spirit of working together and SpedEx being a voluntary process, only the parties can agree to whom their consultant will be. And of course, the consultant has final say as to whether or not he or she will accept a case.
Okay, thank you.
Oh, I'm so glad to get that clarified. Yeah. So to kind of reiterate, we are through the SpedEx process and the good work of our consultants promoting trust between the parties, and in fact that results in the parties going on to resolve their own disputes, which I think is the most effective way to go whenever that's possible. I believe I'm going to have to peek at the next slide, Janie, but I think we're to the point now. Mm-hmm. Yes. So here's our web address, and I'll leave that up for a while while we open to more questions.
Yes. So I think from what I'm seeing from the questions coming in, and please type your questions in now. We do have some time to answer them. That the idea of FAPE, free and appropriate public education, how that is decided is the main issue for the SpedEx resolution service. And someone is asking, are there specific definitions of FAPE for different disabilities? And I know that's a difficult question.
Yes.
And it's certainly the appropriate part of it. I believe there's a case before the Supreme Court right now about that. And whether they're going to expand the definition of what's appropriate education for kids with disabilities. But so can you just speak to that a little bit? How do you make that decision? What is a FAPE issue.
Okay.
Is it, one of the people is asking, is it an accommodation that's not being delivered or a modification that's not being delivered? Is that a FAPE issue that you could bring to SpedEx to try and resolve?
Well, certainly those are two good examples of FAPE. So, of course, this is why we have people who have advanced degrees and professional expertise, and part of the training process is we rigorously review the definition and the concept of both FAPE and LRE. So FAPE, of course, is actually a legal concept, appropriate education, which the courts over the years have come to tell us means that the child must have meaningful benefit from that education, and to the greatest extent appropriate, that special education must comport to or relate to the state's education association or administration's standards and expectations. So it's in the spirit of the No Child Left Behind Act, which is now the ESSA, being in concert with the IDEA. So appropriate education is the specific special education the child receives. Yes, that does include accommodations and related services, as well as specially designed instruction. Specially designed instruction includes the content of instruction, the methods and delivery of instruction, and the performance criteria to which a child is held.
So I think it's an ongoing discussion that it's one of those things that continues to evolve.
Yes. The reason there are IEP disputes, the reasons that they go through the various dispute resolution options, including in some cases courts of law, is because it's a complex thing to decide what appropriate is. It's individualized to each child, which of course is the beauty of special education. And professionals and parents who are concerned with the best interests of the child sometimes have sincere, honest differences of opinion, different interpretations of the standard, and sometimes we have to learn from those disputes how to refine our concept of what appropriate is.
Yeah. And I think some of the people in the audience are still a little confused as to what happens if the parties that are coming together are not in agreement with the resolution. Okay.
Well, I'd like to point out that at no point in the SpedEx process do you abridge or give up any of your due process rights that are yours available to you through special education. So that means you always have the option of pursuing any of the other dispute resolution options, such as mediation, hearing, and facilitated IEPs, and I allude to even going to court if necessary, which I always hope parties can avoid. So at no point do you give those up. If you can't agree, you can pursue it some other way.
Yes. This is an interesting question. How much do the school systems know about how SpedEx works?
Yeah,
do you have an education program going on with them?
We're trying very hard to put the word out. Just as I'm doing this webinar right now, hoping I'm reaching school parties. I speak on a regular basis to groups like the Association of Special Education Administrators here in Massachusetts, try to go to different conferences and programs where they might attend, and twice a year we mail a SpedEx information brochure to special education programs in every school district in the state.
That's excellent.
So we're trying, but the word's not out there entirely yet.
Yeah. I think my question is, how does this differ? The whole approach to this, how is this different from mediation or facilitated IEP? It seems to me to be a very evolved process where it's not them versus us, rather it's a let's all put our heads together and come up with a sensible solution. But I may be wrong about that.
No, I think you're quite right.
Okay.
And that really encapsulates why we're created and what our mission is about.
Yeah.
And of course, absolutely, it can be highly appropriate to go to one of those other options, such as mediation or hearing. Sometimes that's the best format for the parties to work to a productive resolution. But going back to our mission, we are trying to help parties build and or maintain positive working
trust.
relationships. So the more that they can do to resolve their own dispute before escalating the dispute by going to some of those other options, the better. We hope that we're highly efficient. We know that we are. Based on how quickly a mediation gets scheduled, mediations can sometimes actually go faster than the SpedEx process. Again, based on how quickly they get scheduled. Hearings typically take a lot longer to go through. I should note that as soon as the parties come to agreement and the consultant accepts the case, the SpedEx process can begin, and barring unusual circumstances, it takes 30 school days for the consultant to deliver that report. Then it's a range of approximately 2 weeks to 2 to 3 months for the vast majority of cases to determine whether or not they're going to sign an IEP. So there's some variation, and that depends on an awful lot of circumstances.
So what I am hearing is that this really maintains the engagement of the parents, especially with the school, without a break of the trust that can happen so frequently in other types of due process.
That's quite right. It's still the parties working together.
Yes.
And of course, if there are advocates and or attorneys involved, they may participate as well. That doesn't have to be given up.
Yeah. Okay. I think one of our audience members said that she kind of encapsulated it, that you're an uninvolved third party. That's true.
Yeah.
Uninvolved.
But we like the word neutral.
Right, neutral. You don't have any players in the game, so to speak.
Quite right.
And you're stating what you feel is fair or unfair. I don't know if that's exactly what it is.
Yeah, I'd like to say it more technically.
Okay.
We're stating what we believe would be FAPE and LRE for the child.
Okay. And it's always individualized.
Absolutely.
Yes.
Right.
Okay.
Right.
Alrighty. So I think I've answered all of the questions here. If I've not, please go ahead and type it in. Some of the questions that came in the beginning, I think, were answered as we went forward in the presentation. So here's a question for it's an interesting question because it could be a question about neutrality. Are the consultants paid by DESE?
Yes, the consultants are paid by DESE.
Okay. So that kind of puts a little bit of a different, I mean, they do have a stake, but I'm not sure what, they're certainly not a stake with the family of the school.
I appreciate that someone could see it that
Yeah.
way. I'd like to say that I don't see it that way.
Okay.
Certainly, DESE keeps an eye on how SpedEx is doing because they're very interested in whether or not they're spending their money wisely. And so for them, that's not about who wins. And I'd like to address that. Would you remind me, Janie,
Yes.
about the who wins question?
Yes, who wins?
But DESE is really interested in whether or not it's efficient and effective. Is it resulting in signed IEPs? Is it helping parties build and maintain positive working relationships? So consultants really are not answerable to DESE.
Okay.
There's absolutely no review to date where anybody's ever looked at a specific consultant's performance record or something of that sort, if you will. We really do operate quite neutrally.
Let's see.
So I remember I asked you to remind me of something, but I forgot what it was.
Who wins?
Oh, thank you. Thank you. I tried to put it right out of my mind. I hope you don't think I'm taking jabs at the folks at the BSEA who do report who wins on hearing decisions, but I've never understood how they can do that. And I can tell you that as corny as it may sound, in the SpedEx process, the child wins. It's never a case of who wins, the school or the parent, because the parties come together as they should through the teaming process to develop a mutually agreed to IEP. It's a team. They're all in this together. It's not teams competing against one another. And so the IEP that results when they do get signed, which again is approximately 90% of our cases, that almost always represents something new, something organic that grew out of the SpedEx consultation process. So it's not that the party A or party B got what they wanted, which of course you could interpret it that way, but that's not the way we have to look at it.
And someone pointed out that hearing officers are also paid. Are they paid by DESE?
Bureau of Special Education Appeals,
Right, yeah.
which falls under DESE,
Yeah,
is my
yeah.
understanding. Yeah.
I think the only people that probably aren't getting paid in our audience are the special education surrogate parents who are completely volunteer.
Right, yes.
Yeah, so
There are
let's
some
see.
pro bono advocates, but I think they're a little hard to come by.
Yes, yeah. So again, people are trying to get to the core of your service, and I think it's hard for some people to realize this is just a good thing.
Yeah.
But why do you think SpedEx was created?
Oh, I know why SpedEx.
Okay, was it noted there was was there a gap in the process prior to SpedEx being initiated?
You could say there was a gap in the
Yeah.
process. I was not one of the originators of SpedEx. It was founded by a group of individuals, including Marty Mitnack, who's now the outgoing director of the Special Education Unit. And the intent was absolutely to see if they couldn't cut down on the number of disputes that went forward to the more involved processes such as mediations or hearings, and in that same spirit to see if they couldn't help parties, again, build and maintain positive working relationships. That was the inspiration for SpedEx.
Yeah. And this is a great question that just came in. I believe this is a parent. She says I think it's a she, has a pretty bad relationship with her school, her son's school. They've mediated, they filed complaints. She still feels that the IEP is not adequate. How would a SpedEx process work for a situation where it's pretty contentious already?
Sure. Well, we sometimes do get contacts where parties let us know that's already the nature of the relationship. Yeah. So I advise them to think carefully about, would the two parties be open to the idea of taking a fresh perspective and seeing if that could help them reset their relationship, if you will, to come back to the table with new information instead of going back and forth over the entrenched information and opinions they already have. It's so hard for me to give relationship advice and talk about whether or not parties can and will work it out together through this process. So I invite them to reflect very thoughtfully about whether or not they feel like they and the other party could possibly benefit from such a venture.
The fact that she's asking the question makes me think that maybe she wants a fresh start.
I'm hopeful.
Yeah. I've never been to a SpedEx. I would really love to see the process, and I'm not sure that could ever happen, but I have a feeling that you guys are, people that are the consultants are extremely nice.
I'm very proud of our consultants.
Yes. And try to make it very, try to keep contention away from the process and just, I mean, the way you speak yourself is so soothing.
Oh, it's good you say that.
And can lead to a lot of, people calming themselves down and thinking about what they're going to say. Yes, I think it's a great idea. I just really love the idea of going back and starting over again when things have gone so far off the track.
Yeah, I think it's a great idea.
Yeah.
And I'd like to remind people that SpedEx recommendations are not binding. You do not have to accept the recommendations. The report is further good information that must go in the student's file, however. But so the way I like to put it to parties very often is, why not take the risk?
Right. So now we got a bunch of things coming in at once here. Just to give me a couple of seconds here. Okay. To receive SpedEx services, does the IEP have to be fully rejected, or can it be partially rejected?
Oh, it can be partially rejected.
Okay.
And of course, we're concerned about rejections related to FAPE and LRE.
Yeah. Okay. And so do they the consultants take into account and do an interpretation, I guess, around the medical and professional recommendations? They look at all that kind of stuff, right?
Certainly, as they, I know I'm repeating myself, but as they pertain to FAPE and LRE, certainly they would, yes.
Yes, okay.
Yes.
Okay. Again, someone is concerned about the school not being in compliance with the IEP. And how would you answer that? That they're not, the school, she feels that the school's not giving the services that they say they will.
If it's a concern about compliance, then really the most appropriate avenue is to contact the Bureau of Special Education Appeals. Those are the individuals who, first and foremost, are supposed to look into compliance matters. We only address rejected IEP disputes.
Okay.
So.
Yeah. All right. So some people are saying this is a great idea because a lot of parents just want to fight. A lot of schools just I don't know if schools just want to fight, but a lot of people are in it for us versus them. That becomes
Sometimes it feels that way.
Yes, it can really feel that way. So I love the idea, and I didn't realize this until I had spoken to Liz, who is the head of our PCTI, the Parent Consultant Training, that I love that you go back and observe the student after the resolution.
Yes.
That's wonderful, yeah. And that is to, what is the reason behind that?
Well, the purpose of that is strictly and specifically to comment on whether or not the FAPE and LRE that are agreed to in that newly adopted IEP, if that FAPE and LRE are in fact being provided.
So that is kind of a checking on compliance type of thing.
Well, sort of.
Yeah.
I wouldn't quite call it a compliance review, but it's and we provide very minor recommendations at that point about things that might be done slightly differently now that it's in place and in action.
And so someone wants some concrete examples of the resolution,
okay,
and how that impacted the student. We've got maybe 4 minutes left, but if you could maybe say specifically, I think maybe somebody's trying hard to understand the impact this might have made for a certain student, or a student.
Well, of course, one impact it has is that they can move forward with services. We're fortunate in Massachusetts and federally now that you can partially reject and therefore partially accept an IEP. But until an IEP is accepted, newer services, there's a stay put provision, stay hold provision, newer services aren't always able to be provided. So that's, of course, one of the great benefits. As a result of parties signing new IEPs, thanks to the SpedEx consultation, new approaches to instruction have been provided, new coordinations and communication patterns between home and school have been put into place. Students have been moved to new placements, and sometimes that's students being moved to an out-of-district placement. And parties might assume that that's always a one-way thing. We had one case where it was the school district who wanted to place the child out of district and the parents did not. That was the center part of their dispute. So it works both ways. We've also had students return to schools, homeschool from out-of-district placements.
Okay, that could be an issue for a lot of special education surrogate parents whose kids get moved around a lot. So and so the determination of a summer school program would fall under this resolution.
Yes, that's right.
Okay, alrighty. Right. Okay, so we had a bunch of good questions come up there at the end. I think we're about out of time. So David, again, I want to say thank you so much. And
you're very welcome.
If people have further questions, you can certainly email me. There's your email. Okay, great.
There's my email where you can contact me. I'm not sure it was wise, but when we set up the email account, we didn't name it SpedEx. We named it after me.
Okay, that's fine.
A bit of an egomaniac, I suppose. But that's how you can get in touch with me with your questions about SpedEx. And, of course, visit our website as well. Okay.
And one last question, which is a good question. After a student is a certain age, are they involved in the whole process? This particular...
Students themselves, just as they can in the IEP process, may participate in SpedEx.
Okay.
And the older, the more appropriate, among other factors, of course.
That's what I figured the answer would be. All right. I think we have one more. Do we have one more slide here? Yes. Oh, that's just, thank you. Okay, so we're going to send out a SurveyMonkey for people to evaluate. And I guess we'll see you all next month. And thank you so much for attending.
Thank you, Jamie.
You're welcome. Thank you.